in Brisbane. This forum was organised by the University of Queensland, Caxton Legal Centre, Griffith University and Queensland University of Technology as part of the Social Justice Forum series. It was recorded last Thursday at the Banco Court at the Queensland Supreme Court in Brisbane. Can I start off tonight by saying the Queensland Attorney-General and Minister for Justice, Gerard Blay, was invited to take part in tonight's panel discussion. Indeed, he was welcome here, and frankly, I would have preferred him to be on the panel to both argue the government's case and respond to the views of the other panellists. Alas, he declined our invitation. According to the Queensland Government's Safer Streets Crime Action Plan, there is community concern that young people are getting a mere slap on the wrist for the crimes that they commit, and this influences their disregard for the law. Do you agree with that?
Whether or not there's really community concern, I think, is the first point to ask. We're told that that's the story. I don't quite know where that information comes from, but it is a line that is used quite regularly in the political space. Law and order is often used within particularly election environments. It seems to be a vote-winner because, of course, if you make people feel insecure, if they feel unsafe, then they want to do something about it. Unfortunately, from the statistics we see, that is really just a mythology, that in fact our streets are relatively safe. Certainly they're not particularly threatened by young people. We know that only a very small number of young people are repeat offenders. The number of offenders is decreasing. So for us, we're a bit concerned and confused as to why the sorts of reforms that you've alluded to are really necessary.
So you're saying that the claim that youth crime is on the rise, and indeed that more young people are reoffending, is not true?
Well, certainly the statistics for the last few years indicate the number of offenders is decreasing. From the Attorney's own report, it says that from 11-12, there was a 15.2 decrease in the number of young people being dealt with by the courts. So that would assume that things are perhaps improving. It is said that there's an increase in the number of offences, so maybe a smaller group of young people are committing more offences, but the number of offences can vary depending on how police choose to charge, for example, that sort of thing, and whether they choose to charge a number of offences rather than just one or two. So that's a bit difficult, I think, to draw conclusions from that.
April, you're a criminologist, so you deal with stats all of the time on this. Do you agree with what Janet's saying? Is there any statistical base to the claim that we have a youth crime rate?
Absolutely not. The statistics that we've seen both nationally and particularly in Queensland show, in terms of long-term trends particularly, a stabling of the rate of offending. So what we do know is that the likelihood that an individual offender is going to commit an offence today is really no different to what that likelihood was 10 years ago, 20 years ago.
So we have a hardline response to a problem that doesn't actually exist.
Well, in terms of beefing of behaviour, yes, it seems that there is not a changing nature of offending in that sense. But in Queensland, there's something that we do need to be conscious of, is that we have an increasing youth population. So at the moment, we have in Queensland about 400,000 young individuals between the age of 10 and 17. What we do know, based on ABS statistics, is that in 10 years' time, we're going to have another 100,000 extra individuals in the system. So even with the same rate of offending, or at least even a decrease in offending, we need to be conscious of the actual numbers of individuals as they're flowing through the system.
And Janet, what offences do young people typically commit?
Most commonly property-related offences. And I think that's an interesting point because young people are as likely to be a victim of a crime as a perpetrator. And something in the region of 53% of the offences against young people are assaults, and about 32% are sexual assaults. So that's additional. So if a young person's a victim, they're more likely to be the victim of a violent offence, but young people's offending as such is more property-related.
Stephen, before we go any further, we should probably point out that in every jurisdiction in Australia, a juvenile, and we're having a discussion tonight about juvenile justice, a juvenile is defined as a person between the age of 10 and 17 years of age except in Queensland, where it is between the age of 10 and 16, meaning that for the purposes of committing a crime and virtually nothing else, you're an adult at the age of 17. Does this make sense?
No, it doesn't make any sense. That has been enshrined in legislation for years here in Queensland, and we don't quite understand, well, I certainly don't understand why, and we've been advocating to push the age up to 17 to bring us not just in line with the rest of Australia, but in line with most of the rest of the world, developing and developed parts of the world. And Australia's ratified a number of international treaties and consensus statements, the human rights of the child, and all of those treaties state quite explicitly that a child is defined as someone up to the age of 17 and including the age of 17.
And this is unusual around the world. We would define someone as an adult for the purposes of criminal law at the age of 17.
Absolutely.
And Jan, you represent young people. It means, does it not, that 17-year-olds can be sent to adult jails?
Yes, they have special places in adult jails for 17-year-olds. There's Boys Yard in Brisbane Correctional Centre and Arthur Correctional Centre. Those young people cannot have a cigarette. They cannot buy a cigarette if they chose to. They can't be tattooed, for example, but they are held in adult prisons. And can I take up your point about the slap on the wrist? Something that I come to grapple with on a lot of occasions is the fact that by convention in Queensland, an adult who pleads guilty to a criminal offence, if they are sent to prison, they will be released after 30% of their sentence. Under legislation applying to juveniles, not 17s, but to juveniles, they are released after 70% of their head sentence, unless there's special circumstances warranting their release after half. So for an adult, if they go to trial and are found guilty, they'll by convention do about a half of their sentence. A child will do half of their sentence if there's special circumstances or are plead guilty. I don't consider that to be such a slap on the wrist.
So adults get a greater concession on their head sentence to young people?
That's correct.
Why is that?
Look, I can't answer that question, but I can certainly
Because
say
Queenslanders
that globally, for me at least, the
have elected
sentences
a
for children
series of
needs
insane
to be
politicians
moderated due to
who've
that
made
fact.
insane
They
laws for
certainly
them
still are,
at the behest
but
of
there's
insane
a general
police.
creeping up of the head sentence for juveniles, which is resulting in them spending
Everybody
a lot
gets the
more time
government they
in
deserve.
actual incarceration than an
Queenslanders
adult
must
would.
be fucking
Just before we
insane,
leave this
or they wouldn't
issue
want
of
to live like that.
17-year-olds being treated as adults for the purposes of the criminal justice system here in Queensland, Janet, this means rather bizarrely that a 17-year-old found guilty of underage drinking in Queensland because he or she is a minor, i.e. not an adult, is treated with by the courts as if they were an adult. How do you figure that out?
Well, you try to explain it to young people, because I have to tell you, we do a lot of legal education work, and the young people just can't understand that either. I mean, it shows the anomaly of the whole system, that exactly that. You're regarded as being underage for one purpose, but then you break the law in that respect, and you get tried as an adult in an adult court. So, yeah, it just doesn't work.
Until the UN Convention on the Rights of the Child states that detention or imprisonment of a child should be used as a measure of last resort. How significant would it be, do you think, to overturn that principle, which is currently what the Queensland government is contemplating on
Did
doing?
any of my subscribers go to Queensland for a holiday?
Not only from a symbolic perspective, and
They are very, very wicked, naughty, evil people.
How we think of
Queensland does not deserve the support of the rest of the world.
We do know from the evidence that detention
Just like
is
North
not,
Korea does not deserve the
best
support
way
of the rest of the world.
reoffenders. We know that detention is a criminogenic place to put people. If we're going to send someone to a detention centre, it is increasing the chance of them going to reoffend. So why would we want to choose to overturn something where that is going to be the most result?
I mean, it's curious because in that Safer Streets report that I quoted, it said that the community was concerned that kids were getting a slap over the wrist and they weren't respecting the law. The suggestion that the response to that is that we put more of them in jail is that it will act as a deterrent, and that, I don't know, possibly the implication is that if they seem to be saying that there's much truth in that.
Well, there's definitely no evidence at all that suggests that detention is the place to assist people to reoffend. There is a whole range of evidence as to what other programs and alternatives that are available. Best evidence that suggests that you can reduce reoffending, particularly for moderate offenders, by in the order of about 15%, which is something that the detention centres definitely don't have the efficacy to do. So from a cost-benefit analysis too, you want to look at investing in policies that have an increase in safety, or increasing the chance that someone in the long term is not going to continue to reoffend.
We'll talk about that, early intervention programs, which are often claimed by governments to be very expensive. But of course, one of the things we know about putting people into prison and youth detention is that it is also extremely expensive. Jan, it makes me wonder then whether or not this is about purely punishment rather than deterrence or any other measure.
Well, I call it politicking, actually, but certainly all of the evidence that I've seen and my experience dictates that the best way to create the offender is to put them with offending peers. So, look, I'm not the academic here, but $600+ a day to keep a child in detention, I think a bit of creativity for
$600 a day.
would certainly...
Gee, that employs a lot of Queensland football buffheads, doesn't it?
How best to rehabilitate people, how best to re-engage them with their community, their family, their schools in particular. There's going to be money much better spent than popping them away and overcrowding, or, God forbid, building more detention centres for young people.
Yeah, I was interested, April, that you were telling me that a large number of young people who are already in detention are there despite not being convicted of anything. They are, in other words, they're on remand. Why are people spending so much time in detention when they haven't even been for the courts to have their case tried?
Well, it's an interesting question. It's something that we've seen
Victory,
as a trend
hurrah!
also across all of Australia. We've seen an increase in the proportion of individuals that are in detention centres on remand. Unfortunately, in Queensland, we seem to be ahead of the game. We're not only, the national average is about 50% of those that are in a detention centre in remand, but in Queensland it's about 75%. And often, more recently, we've been told that it may be getting even higher than that. There's two reasons that I can see is that we're admitting more people to remand, and the other thing is that we're keeping people in remand for a lot longer than what they have been in the past. So, in terms of why do we choose to send someone to a remand in remand is a question about bail. Why are we not being able to find alternatives in the community and other ways in which to spend what would otherwise be a significant amount of money? I mean, every individual is, as Jen was saying, it's over $600 a day to have somebody in the detention facility. It's the same instance for those in the room. So why can we not use that money better spent and find alternatives to secure replacement in the community or bail programs and such things?
$240,000 a year, the cost to imprison a young person. That seems like a lot of money that could be spent more usefully. Jan, do you have clients who are sitting in remand because they can't get bail for one reason or another?
Awful lot of remedial school teaching. Awful lot of remedial social work. $240,000 a year to keep one child in jail for 1 year.
Ahead of the game in terms of their ability to identify the issues that are putting people at risk of losing their accommodation. Because ultimately for bail you need an address. The court needs to know where you are. Look, Janet will be able to talk about how many children interface with the child safety system.
I could personally live for 12 years on that money at today's prices.
In brokering psychological
12 years of life expenses
to the families.
For one man on one day in the 21st century.
Perhaps having respite for the family and supporting that bail accommodation so as to save some money.
Paying self-righteous Queensland middle class, otherwise economically unemployable buffheads to imprison children.
Accommodation to go to. I think there are a couple of key things here. One is that for the vast majority of young people that will come before the court or come into conflict with the police, they may come in to have an interaction once or twice, they may be cautioned by police, they may go to court once or twice. But it's a very small group of young people, who become our repeat offenders, who become entrenched in the system. Those are the young people who tend not to be able to get bail. That's because those young people are becoming involved in the system because of their family circumstances, their own background. Stephen will probably be able to talk more about their mental health issues, which is an increasing problem we're seeing among young people. That all destabilises their accommodation, particularly if they've got family dysfunction, problems at home, those sorts of things. They may say they can go home, but then that all breaks down and, they can't. And so the point of our youth bail accommodation support service, which the Youth Advocacy runs, is to try and manage that, is to try and we have brokerage money which can assist us to help find those resources which can sort of stabilise and maintain a placement and keep them safe, secure and in a place that the magistrate or judge can feel that's okay and that we've got some confidence they can stay because there's someone keeping an eye out. But that really is about that smaller group of young people for whom their life is going a little bit off track.
Yeah, because these are not kids who come from good homes who've done a stupid thing on a Saturday night, by and large, who are going to be safely released back into the family home and looked after by responsible parents. But perhaps to talk a bit more about that, Stephen, you could give us a bit of a profile of the children and the adolescents that you see when you visit these youth facilities, their backgrounds, the state of their mental health and so on.
Yeah, you're right. I mean, there's the occasional young person who goes in there because they get really drunk on a Saturday night and do something stupid and tragic, and it's a tragedy for everyone. But the vast majority of these young people come from backgrounds characterised by abuse, neglect, poverty, itinerancy, intergenerational trauma. There's been multiple studies on this done across the world, plus here in Queensland. We've looked at our young people in the Brisbane Youth Detention Centre. About 75% of girls, about 65% of the boys screen positive for significant mental health problems. We've looked at trauma. Basically, if you're a young woman in BYDC, you've been exposed to significant trauma until proven otherwise. The vast majority of these young girls, when you talk with them, admit that they've been sexually abused, physically abused, and not just once or twice, but multiple times. And the boys too. So you've got a heavily traumatised cohort of young people who have been traumatised not once but on multiple occasions, who come from backgrounds characterised by poverty and neglect, who have long-standing childhood issues that have impacted on not just their mental health but their psychological well-being. And that's basically the summary of the young people we see day after day in the Brisbane Youth Detention Centre, in all youth detention centres. And it mirrors the studies done across the developed world in the US, in the UK, mainland Europe and Canada.
So breakdown in relationship with parents, often toxic home environment.
Yeah, toxic home environment, toxic peer group. I didn't mention 90% also admit that they have significant or polysubstance use as well. Many times it's self-induced in part to try to get rid of the bad memories that are associated with the trauma and post-traumatic flashbacks that they're having, and so you get this vicious cycle.
And the kids who have mental illness, is that mental illness being treated? Is it stabilised? Are they being effectively medicated where necessary?
Well, there's really two groups. There's the groups that are over-medicated and have been put on lots of medications, some licit and some illicit, and there are those that have been undiagnosed. And in fact, what I prefer to do when they come into the detention centre, paradoxically, is to try to take them off all their medication, because I certainly don't advocate for young people getting into youth detention on mental health grounds. But if they're in there, one of the benefits that we can do is at least they're in a reasonably stable environment and they don't have any access to illicit substances. So we can drive them out, take them off all their medication, and actually make a good assessment on their mental state in that type of contained environment. That's certainly not a reason for them to go into youth detention, but it's something that we can try to do to try to help them when they're in there.
So Janet, these adolescents, these juveniles that Stephen's just described, they're coming into contact with the police after some infraction with the law. And Stephen's just given us a breakdown of the complexity of the issues they face, difficult backgrounds. How are the police equipped to deal with this, to make sense of this? Are they simply just processed through as any other offender is, or do the police have the skills to understand what they're dealing with here?
I suspect not, because they are young people with very complex issues, and we would be arguing that anybody working with that group of young people needs to have good training, good skills. I mean, as in all professions, there's police officers that will take the time, the trouble, do their best, will perhaps make referrals, that sort of thing. There'll be another group that go, it's all too hard, let's just pass them through, we'll put them into detention anyway, they'll sort it out over there.
They're probably a pain in the arse too.
Oh, absolutely.
As well. You're probably not feeling like you're going to cut some slack to some kid who's mouthing you off.
I mean, it is, I don't think we should underestimate the fact that these young people are challenging to work with. That's absolutely true. I would not say that the client group at our centre is all warm and fuzzy and cuddly at all. But the reality is they are all young people with the emphasis on the people, and that's what we focus on. It's about trying to find out for those young people what is going on in their lives, and therefore what is it that we need to be doing with them to try and break the cycle of them getting involved in conflict with the law at whatever level.
But because they're like, as you described, challenging kids, they're easy to demonise. They often wear clothes, have ostentatious tattoos or piercings or whatever, are confrontational in their behaviour. So it's very easy to stereotype and demonise these people, and for the community to feel fearful about them. And perhaps that in turn allows for some of the measures that are currently being considered to be put onto the table, because people are inclined to want to react emotively to what they're seeing. That kid just needs a good lesson, and throw him behind bars for a few months and sort him out.
And that's right, and of course that is quite a simplistic response, but yes, that is
Queensland is full of very simplistic people.
The fact that there isn't good information out there about the group of young people in particular that we're talking about, that this information doesn't get put into the paper. We just see headlines in the paper that, as you say, demonise young people. I think as older people, there's this tendency for us all to look back and go, oh, when I was younger it was different. And it's interesting that every single generation says that. And I have this really wonderful quote that talks about more and more children are committing crime, and if urgent steps are not taken, the end of the world as we know it is fast approaching. That was said in the 8th century BC by a Greek poet. And you can trace throughout time these sorts of quotes. So there is nothing new that's happening in terms of young people being challenging. Certainly that whole adolescence thing about risk-taking, about poor judgment, which is all about them grappling with growing up, developing, becoming adults. I mean, that's part of their job description. But when you overlay that with the issues that Stephen has described, it makes for a difficult task.
And Jan, these are the young offenders who may well be more likely to end up in jail if the principle of detention as a last resort is overturned. That would have profound implications for a number of your clients.
Look, it would. I have full faith in the judiciary to apply principle where it needs to be applied.
But the judiciary have their hands tied by government legislation. There's a limited degree of movement.
Certainly, it means that your first response is not the best one, and the same principle applies to if we're proposing making a breach of bail condition an offence. Now, for juveniles, that at the moment is not an offence. Certainly if I find this
Here endeth part 1.